Good morning. I'm Hal Crenton. I'm the Dean of IIT Chicago-Kent College of Law. On behalf of faculty and staff, we're delighted to welcome you here for the conference this morning. The 8 cases that will be the focus of today is really a testament to the incredible rapid rise of intellectual property as a discipline as seen by the Supreme Court. Of course, it's no stranger to us. Even our name as Illinois Institute of Technology, Chicago-Kent College of Law illustrates the close tie between technology and law. And you can see that in many law schools around the country, but just to give you a flavor for how IP has risen in the ranks, when I went to school, there was probably 1 or 2 courses taught in IP. We teach about 35 courses. About 10% of our students graduate with a certificate of distinction in intellectual property. We've started an LLM in international intellectual property, and we started a cross-disciplinary master's program here dealing with computer science, with business, finance, and law put all together as a whole new discipline of understanding IP. So I congratulate you all for being in this exciting new developing body of law as it's being shaped by the Supreme Court, as we'll see. But I also want to thank the sponsors who recognize the importance of this study and, of course, have helped all of us get here today. The luncheon sponsor, Morgan Lewis, the reception sponsor, Steptoe and Johnson, the coffee break sponsor, McDonald Bainan, session sponsors, Banner and Wickoff, Innova Law, McAndrews, Seyfarth Shaw, and of course our own SCIPR, or our Institute on the Supreme Court for the United States. And I have the pleasure of introducing Ed Lee, who's the head of our IP program and the major domo for this conference. Ed.
Thanks, Hal, and thank you all to the early birds who showed up for the first session at 8:30. I really appreciate it, and our panelists do as well. As Dean Crenton referred to, this is a very historic term for the Supreme Court in IP cases. We'll be discussing this a little bit later in the afternoon, but this is the most IP cases the Supreme Court has ever heard in one term. Depending on how you count them, it's either 10 or 8. If you include the 2 Lanham Act cases, it's 10, and that's almost double, I think, the most previously for a single session of the Supreme Court. Now, fittingly, to sort of commemorate this historic term, we have attorneys from every single one of those 10 cases here to discuss and analyze those cases and the opinions. We also will have, hopefully via Skype, the only individual person who is not a corporation involved in these 10 IP cases, Paula Perella. And we also have distinguished law professors and scholars, some of whom wrote amici briefs for these 10 IP cases, some of whom wrote blog posts and articles related to these 10 cases. So it's a quite amazing group of panelists that you'll hear from today. And if that doesn't get you excited, we have Mr. David Kapos to deliver our keynote address. If you don't know David Kapos, you're probably not familiar with patent law in the United States. He probably was the most important policymaker at the USPTO, responsible for changes in the American Invents Act that helped to harmonize United States patent law with basically the rest of the world in many different aspects. So that's what you have to look forward to today. Now, before we turn it over to our first panel, I just want to go over a couple housekeeping matters that some of you probably will be interested in. First of all, Wi-Fi access in the auditorium you can find on page Roman numeral 7 of the program on how to access the Wi-Fi. And for some of you who are on Twitter, I would encourage you to live tweet this event at hashtag SCIPR 2014 if you're on Twitter. And then finally, for those of you who are getting CLE credit, remember to turn in your evaluations at the end of the conference. You should have picked up an evaluation form at the end of at the table, at the registration table at the start. Okay, that's all I have, and you'll be hearing from me later on in this conference, but I will just turn it over to David Clough, who will introduce himself as well as the rest of the panel.
I'm Dave Clough, and I'm the head of IP at Morgan Lewis here in Chicago. I'm a graduate of this institution when they only actually had 2 IP courses, and I only took one of them, and it wasn't patents. Our panelists today are Dominic Perella, counsel to Highmark and partner at Hogan, Lovells in Washington. We also have Rudolph Telscher, who was counsel to Octane Fitness, who is a principal in Harness Dickey in St. Louis. Next to him is Constantine Trela, counsel excuse me, to Allcare Health and a partner at Sidley in Austin here in Chicago. And at the end, Professor David Schwartz of Chicago, Kent. In the first case we'll be talking about today, it's Octane Fitness versus Allcare Health. I will just give you a brief syllabus of the case, and I hope that I won't have to say another word after that, but we'll see. In this case, the court addressed the issue under 35 U.S.C. 285 as to what an exceptional case is and what are the standards for determining an exceptional case. In this case, the Supreme Court took on the standard for an exceptional case that was promulgated by the Federal Circuit in 2005 in Brooks versus Dutelier International. In that case, the Fed Circuit, quote, abandoned a totality of the circumstances and put into place a new standard that there must be clear and convincing evidence of some material inappropriate conduct in the prosecution of the patent or conduct of the litigation, and the even more stringent standard that litigation was brought in subjective bad faith and was objectively baseless. And the court in that case found that objectively baseless was a question of law reviewed de novo on appeal and without deference to the district court. As a result of this, a number of big fee awards were vacated over the years. In Octane Fitness, the court decided that Brooks was unduly rigid and does not comport with the plain language of 285, which simply requires a case to be exceptional and does not require that the case be objectively baseless or subjectively baseless, or otherwise, and another standard plugged in this case, was otherwise independently sanctionable. The court held that the litigants need only prove this by a preponderance of the evidence and not by clear and convincing evidence, and that the court stated that an exceptional case stands out from others with respect to the substantive strength of a party's litigation position, considering the governing law and facts, and an unreasonable manner in which the case was litigated. And these cases for these exceptional cases were to be determined on a case-by-case basis at the discretion of the district court. The final holding was that the standard should not be clear and convincing and have not done so with. One of the issues that came up here, and this is one of the first things that I'd like to ask here, is in this case, the question that comes to mind to me was, first of all, is it a political position by the Supreme Court that they should be sort of directing traffic and restricting or increasing the flow in patent cases?
Start with me?
Yeah.
I mean, I think that was a secondary consideration. That's my personal view. I defer to Rudy, he argued this one. But my personal view is both in Octane and in Highmark. In both sets of briefing, the people who are on our side of the case and we ourselves made points about playing traffic cop, about patent trolls, about the massive increase in the number of patent lawsuits and the difficulty in getting fee awards. I think that all along that was a secondary consideration because, to my mind at least, the law was clear, both in this area and in other related areas, that the standard the Federal Circuit had adopted was a non-starter. And so I think the Supreme Court was able to resolve the cases in our favor without having to delve too deeply into political quasi-policy considerations.
Yeah, it seems to me that this isn't the first time the Supreme Court has gone to the Federal Circuit and said you should treat statutes like every other appeals court in the country and not just in your own specialized way. Rudy?
Well, I think that's right. The statute starts with one word, exceptional, and as lawyers, we're trained to look at one simple word and turn it into a massive lawsuit, and that's what happened here. But as Scalia would say, and most of the justices on the bench would say, you start with the plain and ordinary meaning, and when you look at the word exceptional, what it meant back in 1952, when we actually went in and pulled dictionary definitions for 1952, it meant out of the ordinary. And that's a far cry from frivolous and subjective bad faith. So the standard under Brooks was impossible. I think the Supreme Court had, as you said, and I think correctly so, had no difficulty determining that the plain meaning of exceptional was inconsistent with the notion of an extreme standard that is really impossible to meet. And when you look at it statistically, from 2005 to 2011, there wasn't a single fee award affirmed by the Federal Circuit that had to do with the merits of the case. What does that mean? That means that there might have been a couple that related to inequitable conduct or litigation misconduct, but when it came to saying that the case that was brought was too weak, zero from 2005 to 2011, during a time period when we all know that there was a lot of public sentiment from the companies in this country that the lawsuits were getting weaker and weaker. Since Octane was delivered in April of this year, there's already been 10 award of fees in just those few months. So already the case is having an impact on litigation in this country.
Connie, would you like to weigh in on this?
Well, I think just to pick up on what Dominic said about the statutory question, I think that's right. I think this was, in the Supreme Court's view, certainly an instance where the Federal Circuit was treating patent law as somehow different than regular law and reading statutes in ways that you wouldn't read them that way in other areas. In that sense, it was very similar to the eBay case, where you had a generally applicable statute or generally applicable language, and the Federal Circuit had come up with a patent-specific meaning. I think in the Supreme Court's view, the Federal Circuit did the same thing here. And Dave, just to pick up on you made a comment about was there a political sort of angle to this. I don't think, I agree that it was not a primary factor, but I do think you see in these cases and in some of the other ones that'll be discussed later, I think all of the publicity and concern about patent trolls and non-practicing entities, I think that has had an impact. Now, Professor Schwartz is more of a number cruncher, so he probably has some views on whether there really is a crisis in patent troll litigation, but I think that message, how accurate it is another question, but that message got through to the Supreme Court, and I think you see that concern sort of underlying a number of decisions, including these.
If I could just break in for a moment here, I'd just like to take a minute to weave in the Highmark case, in which the court determined that the exceptional case determination was reviewed on an abuse of discretion basis, which falls directly out of the Octane case. But getting back to what Connie was just talking about, a little bit about trolls. David, could you give us your thoughts about what the effect that these cases might have on non-practicing entity litigation? We shouldn't say trolls, I don't think.
Okay, well, I think that, on balance, this case made it easier for the courts, the district courts, and the Federal Circuit to affirm findings of fee awards. And I think that, as Rudy said, that we're seeing more of that. So there was already some discretion. I think that there's going to be more fee awards. And so, the kind of media narrative on these non-practicing entity cases, or at least some of the cases, they're very weak claims with cost of defense settlements. And so I think that this, on some level would encourage people, defendants, to litigate rather than settle if they thought they had a better chance of recouping their fees. But it's, the standard is not you get your attorney's fees if you prevail. It's still that it's the kind of outlier case or the uncommon case. And so I think that there's still going to be a lot of pressure on accused infringers if they get a settlement offer that's, well under the cost of litigation to settle these cases.
Anybody else further comments on that?
I just agree. I think it's well said.
Yep.
It's just, we said that this is not a political issue, but This year, we all know that there was legislation pending in Congress regarding fee shifting in these cases. Do you think that these cases have hindered the opportunity to change the legislation for fee shifting?
My instinct is that they have not. I think that there will be momentum going forward in Congress for this sort of legislation. Whether it will ever get over the hump, I don't know. But I think that as for the exact reasons Professor Schwartz mentioned, the changes that are going to occur here in terms of the number of NPE litigations that are brought without a reasonable basis and the willingness of companies to fight those in court as opposed to settling is going to be changed only at the margins. For exactly the reasons Professor Schwartz mentioned, you still have a situation where, faced with a settlement offer well below the cost of defense and the possibility, but far from certainty, of a fee recovery years and years down the road, many companies will still want to settle. And so I would imagine the pressures that were brought to bear on the legislators to do something about that will not decrease significantly.
See, finally, we have a chance for robust debate. I disagree.
Yeah, as do I.
Okay. Well, go ahead.
So, no,
Feel free.
I mean that in good fun. My view is the Supreme Court in our case, they delivered their opinion in 6 weeks, which was well under the expectation of 3 months. I think it was definitely on the Supreme Court's mind, and we're all guessing, of course, but I think it was on the Supreme Court's mind that there was legislation out there. I think there was a lot of concern about the legislation. And I think the Supreme Court saw it as an opportunity to fix the statute, give district courts more discretion, and alleviate the need for legislation. And what we've seen is legislation being taken off the board as a result of it. Now, when you talk about fee shifting, there's only 2 ways you can go about it, really, in my 2 general ways. One is loser pays, and I don't see loser pays legislation going through. I think it would have a chilling effect on the patent system. I think smaller companies couldn't afford to take that risk. You go up against a large company who has Sidley, who is a great value but very expensive. And
Worth every penny, though.
Worth every penny, not debating it. And I just need to figure out how to get in on that gig. So, I think that small companies can't afford to do that, and 75% of this country is built on small companies. So I think you're not going to see that kind of legislation. The other legislation that was on the board was, for example, if you could show it as a non-practicing entity, fees would be shifted unless you could show your actions were reasonable. In my view, that is basically no different than the statute or the standard that the Supreme Court has articulated. What the Supreme Court has said is your case has to stand out in terms of its substantive strength. You want to boil that down, in my view, that just means you've brought an unreasonable case. So I think what the Supreme Court has done is consistent with the only type of legislation that I think would have gotten through.
And I don't disagree with anything that Rudy said, although I take a more simplistic view of it. It seems to me that whether the Supreme Court intended to obviate the need for legislation and whether it in fact did that, I think Congress will see this as a solution to the problem, or at least a partial solution to the problem, and at best will take a wait-and-see attitude and just see how things play out after Highmark and Octane. So I would not expect to see this, come back onto the legislature's table for a while. We may see it again a few years down the road, but I think they're going to view it as a problem that has been taken off of their list.
Yeah, can I just briefly chime in? So I'm not sure that I agree. I do think that politically the proponents of reform made fee shifting a central part of why we needed reform. And these pair of cases took some of the wind out of the sails of that argument. However, the reform that they were seeking was much broader than what these cases allow, where it's just cases that are out of the ordinary. The proposal that was on the table, at least the one that was in the Innovation Act, was essentially a default that fees are shifted unless the positions were reasonably justified. And I think that the proponents of patent reform, that's a really important change, and I think that is something that they're going to re-raise, soon, right in the beginning of the next Congress. As
a practical matter, after this case, do do you think the fee awards, how do you think fee awards will be distributed? Do you think the plaintiffs will be the beneficiaries, the defendants will be the beneficiaries, or we just won't be able to tell?
Can I chime in with a little data first? And so in some work that I've done with John Allison and Mark Lemley, what we've done is we've looked at lawsuits filed in 2008 and 2009, patent cases, that were resolved on the merits, either summary judgment or some sort of trial. And of those cases, the defendants won 75% of the patents, and the patent owners won 25%. Now, that's not completely surprising because defendants, in a sense, have two chances to get to a final judgment. They can win on summary judgment or they can win at trial, while a patentee has to win both. But even though these cases, I think, allow fee shifting to go both ways to a prevailing party, I just think that because of the way that summary judgment and trial are set up, there's more opportunities for defendants to be the prevailing party or accused infringers.
Well, it's hard to argue with a data-driven answer, so I'm gonna defer
There's
Schwartz
lies,
on that one.
damn lies and statistics.
Well, and I have the same view, although not based on any analysis of the data, but I think it's likely that the courts will view defendants and plaintiffs a little bit differently. I think if a defendant is found not to have meritorious defenses, I think the district courts may, in the first instance, think about willful infringement as we will deal with that under the rubric of willful infringement, whereas you don't have that counterpart when you're looking at assessing fees against the plaintiff. So, although it's clearly not the intent of these cases, I think you could see sort of a different standard applied to weak plaintiff's claims versus weak defendant positions.
But presumably that would have been the case before as well. And
Oh yeah, no,
easier.
absolutely,
Yeah.
absolutely.
The only aspect I would add to this is that if you win at summary judgment, whether you're a plaintiff or you're a defendant, you've got a district court judge who's looking at whether you brought a reasonable case or whether you defended the case in a reasonable way, how strong your defenses were or not. I think for plaintiffs and defendants, it's going to apply equally. I think where there's probably a disparity, and this is just the nature of the system, if you're a plaintiff and you prove your case and a jury finds willful infringement, a jury decides whether you're a willful infringer or not, the judge. That emboldens a judge, in my view, to feel more comfortable awarding attorney's fees when there's a willful infringement finding. And I can tell you, in my view, it's far easier to get a jury to buy into willful infringement than it is to get a judge to buy into a patent case is weak. So I think the plaintiff has the edge if they get to trial and get willfulness.
You mentioned something, and I'm sort of jumping ahead here, talking about motions for summary judgment in these cases. Judge Dyke recently wrote a commentary, which, by the way, I haven't had much of a chance to read, which basically was headlined, are summary judgment motions basically required before you can make a motion for an exceptional case?
Well, I don't think so personally, because in my view, if I got an expert on the other side who's saying something contrary to my expert, I may decide that, on the paper record, summary judgment isn't going to go through. But if I get to trial and I can impeach that expert and show that he was really full of it, I think a district court is still in a position to say, yeah, your case fell apart at trial.
And also I would just add to that of course, that view that you would have to have a summary judgment adjudication in order to get an exceptional case finding depends on the idea that exceptional case findings largely will arise out of, legally unreasonable positions. And of course, the whole point of the Octane decision is there are all sorts of other ways a case could be exceptional. Litigation misconduct, an expert who is taking frivolous positions, et cetera.
Evidence of economic coercion, right?
Sure.
Yep.
So I think there are any number of ways you could get to the Section 285 award without a summary judgment victory.
It certainly helps, though. I think if you get a summary judgment victory, it's kind of a red flag that the judge needs to look closer.
Well, and actually, I think, Dave, that Judge Dyke comment was actually in a case in which he was sitting as a district judge. That was one of the reasons that he gave for denying a fee motion, and I don't remember which party was the one that was being, from whom fees were being sought, but because the other party had not moved for summary judgment, Judge Dyke considered that a factor against awarding fees.
Well, let's get down to a little bit of the nitty-gritty. We say, what does it really mean? What does exceptional mean? I mean, what stands out from others or unreasonable litigation tactics? Could you give us any comments and thoughts about what kinds of things may fall under that rubric?
I'm
Go ahead.
happy to take the lead on that. I think in most cases it's going to start with, how strong were the merits of the case? Did the plaintiff bring a case? We all get that hard-fought litigation should not result in a fee award. So, did a plaintiff bring a case that was too aggressive, that was too weak? You're going to look at things, for example, and it happened. There's a Knoxell decision from '85, which was authored by Ginsburg and Scalia, in which a company from the East Coast sued a fireman who was selling barbecue sauce in San Francisco. He sued him in Washington, D.C., and Scalia and Ginsburg in '85 found that aggressive venue behavior alone made a case exceptional. One of the things that I would encourage anybody who's looking at a case and they think it might be exceptional is to look at the economics of it. Normally, and it doesn't apply always, but normally a big company suing another big company doesn't have an incentive to bring a bad case because, the big company's going to defend. So where I see abuse, it comes in two areas. One, a bigger company suing a smaller company, hoping that the smaller company can't defend, and no matter how weak the case is, they're going to try to leverage a settlement. The other area is non-practicing entity cases, and I'm not a troll hater. I think, if you find a non-practicing entity that has legitimate technology that's legitimately being used in the marketplace, there's no problem with bringing that's a property right. However, what we saw over the last 10 years was, I think the goods got picked over. The first guy that was figured out the whole troll angle on this found great patents, and they were making money. As the goods got picked over, the cases got weaker and weaker. And I was in the trenches. I've been down in the Eastern District of Texas on many cases, and they've gotten weaker and weaker. Some of it borders on extortion. How does that system work? Works by, suing 40 different defendants. You go to one defendant and you say, hey, give me $200,000. I say to you, your case is bad, I'm going to defend it. They're like, well, I'll throw you back in the heap and I'll talk to you later. They drag you long enough that you're finally like, I just got to pay. So, I think looking at the economics of a case is important when you're trying to bring these things because it helps the judge to understand somebody's motivation for bringing a weak case.
I kind of wonder whether the motivation, it seems to me that it ought to turn on whether the case is in fact, exceptionally weak. I don't think that the motivation should matter at all. And my view is that the way to do it is probably the objective prong of the old Brooks furniture test. Would a reasonable person at the outset of the case, knowing what, having the information in hand, think that there was a reasonable prospect of prevailing? And if it doesn't meet that standard, then it's a weak case. It doesn't matter whether you had a good reason for bringing it or a good financial reason for bringing it or not. I don't think district judges will want to get into the business of trying to psychoanalyze the potential motivations of plaintiffs. Obviously, every plaintiff who brings a case, they either want money or they want to stop a competitor or some combination of both. So I don't think that is a worthwhile way for district judges to be looking at the fee question.
So to chime in a little bit, I do think that there's, this fee question hinges on two different aspects. One are the merits of the case, right? Is it like an out of the ordinary? And then the kind of behavior of the litigants, right? And so is there litigation misconduct or some other reason that would favor a fee shift? And so the district courts are not actually equally situated, and the judges are not equally situated to evaluate both of those. So in some jurisdictions, like here in Chicago or in San Francisco or in Delaware, the judges have lots of patent cases, and I think they can say, I know like this one's really weak. But in other places, like we can think of in Arkansas, they don't get that many patent cases. The judge might not have a sense on whether this case is an out of the ordinary patent case. With respect to litigation behavior, I think the judges are actually, experienced judges know, this was too rough of a tactic. This was kind of over the line. And so I think that they're probably better, in general, experienced judges at evaluating that litigation misconduct prong.
Your reference to experienced judges actually raises an interesting question. The standard is, does it stand out from the normal case, the mine run case? What does a new judge do? All of her cases stand out at the beginning. A new judge in this district might have a very different view than Judge Shader, who's probably seen thousands of cases, would have. But although good luck in front of Judge Shader trying to avoid a fee award. So I just, you kind of wonder how in practice that standard actually gets applied.
Yeah, what's interesting is, what do you think the Eastern District of Texas, how they would handle this, given the fact that they have a massive number of these troll cases, many of which are very weak? How does one stand out from another against a background like that?
Well, to my way of thinking, I don't know that it's looking at a body of cases and saying, does this case look different than the others? I think it's really an expectation of reasonable litigants. Mm-hmm. I expect a patent owner who has a patent that has commercialized it and a defendant who has copied it too closely to bring a hard-fought suit, and I expect them to act in a reasonable way. So we kind of have an expectation of what reasonable people will do, and I think when we're talking about a case standing out from what we would expect, it's really in that regard. It's not a numerical example. As to the Eastern District of Texas, it's almost a separate issue. I don't know that the Eastern District of Texas judges are going to look at it and say, does it stand out from others because others are weak? I just think Texas is a pro-plaintiff jurisdiction. I don't mean that disparagingly to the Eastern District of Texas. I'm down there all the time, but you can expect it to be harder to get a fee award in Texas. It would be my Eastern District of Texas, in my view.
Do you think we'll see more forum shopping here?
I do, for sure. I think you're going to continue to see. I mean, one of the things I face, and I don't know how many here practice in district court, but when you're down in Texas, it's amusing to me now that when I dig into the facts, the plaintiff who was from California now lives in the Eastern District of Texas. The plaintiff who was from the East Coast now lives in the Eastern District of Texas. Now, granted, it's a shack with a door that has a bar on it, but he lives there, so you can't get a 1404 transfer out of there. So you're going to see forum shopping for sure.
I think litigants ought to take heed, speaking of bad litigation behavior, in view of two recent findings by a couple of district courts that two very prominent firms in the United States were abusing, had abusive deposition practices, where there would be 198 or 205 objections in each of these cases. Let that be an object lesson. I'm sure the courts would love to latch on to that.
Well, that, and I'll also make one other point. There's a Cree-Agree case out there. It was a Northern District of California case in June of this year, where the judge basically found that the plaintiff had acted unreasonably, not only in terms of the case it brought, but its litigation conduct, but then the judge went on to find that the defendants also acted unreasonably, so he denied fees. So if you have your mind on trying to get fees and you think you have a good case, be careful how you're acting, because Cree-Agree serves as an example that it can be held against you and ultimately cause you to lose.
Yeah, getting back to your forum shopping question, though, the deference that's given to district court judges in Highmark makes it so that it's, once a district court judge would deny fees, that's likely to be affirmed. And so once everybody, once there's been sufficient period of time that there's differences among districts that's evident to the litigants beforehand, I think you will see I don't know if it's Eastern District of Texas, but if there are certain jurisdictions that don't award fees and the plaintiff picks the forum, that people will move there quickly.
It'll be interesting to see whether, the Eastern District of Texas is an obvious example, but it'll be interesting to see whether there are district-wide tendencies as far as fee awards are concerned. There are a lot of judges in the Northern District of Illinois. I don't know whether they're all going to have the same view on awarding fees, and if you don't have some sort of district-wide tendency, that kind of, makes forum shopping a little bit risky, because you don't know who you're going to end up with. Eastern District of Texas may be different.
I was going to say, not to mention the fact that if you're doing some forum shopping, obviously the primary consideration is going to be, will you win the case on the merits. At the margins, the likelihood of a fee award might shift things, but I think it'll be a small effect.
Yeah.
Well, I think we can look forward to 3 or 4 years down the road when David publishes his statistics with regard to these issues. As another point, do you think that maybe the bar was lowered a little too much here? Do you think the district court judges might have too much leeway here?
Well, so there's two questions, right? One is the award, and the other is the way it's reviewed. I don't think they have too much leeway with respect to the award. I think what the Supreme Court said was right and fairly obvious, which is, there are all sorts of different ways a case can be exceptional, and this is something district courts should be deciding in the first instance without these strict standards that are cabining their discretion. I think that makes a lot of sense. I don't think it lowers the standard per se. It just stops district courts from being forced to put their analysis into these strange boxes. With respect to review, In the Highmark case, one of the main points that our opponents made was the very fact that there are all these district courts out there that don't often see patent cases. They're less familiar with patent law in general, and of course they also don't have, as Connie was talking about, a run of cases against which to judge any particular litigation. And so that's a good reason, my opponents said, for there to be closer scrutiny of these fee awards on appeal. Obviously, especially after Octane and the adoption of this very discretionary, exceptional case standard, that argument was rejected. And so I think, will there be cases where a district court really doesn't understand the patent law too well and goes ahead and makes a fee award? I think there will. However, if the district court bases that award on a mistake of law, obviously, the federal circuit will still have room to correct that. So I don't know that district courts have been left without any guidance and made uncorrectable in any way.
And I would add to that, I think district court judges, whether you're in Arkansas or California, understand that this still is an exceptional case. It's not one where you just routinely award it. And so I think the district court judges around this country are smart, even the ones that don't have many patent cases. I think they're going to be reluctant to award fees unless you make a compelling showing. And also, we're already seeing an emerging body of law under 285 upon which even the judge in Arkansas can draw upon to try to figure out whether he should award fees in a particular case.
Yeah, I am inclined to agree with that. I think obviously we'll have to see how things play out, and I'm sure there are going to be some district judges who go overboard on this. But when you think about it, the system entrusts a lot of very important decisions to the discretion of district judges, and decisions that have much more of an impact on the ultimate rights of the parties. Evidentiary rulings, trial management rulings, you can have 10 hours to present your case and 10 hours to present the defense, and we're comfortable having those kinds of decisions reviewed on an abuse of discretion basis because the district judges are on the firing lines. They're in the best position to make these judgments, and we as a system have decided to trust them, and I think these rulings will fall into the same category, and there's no reason to think that district judges are more likely to mess these up than these other, I think, more important rulings that they make.
Any other comments? Because I think we should be opening the floor to questions here in a minute.
The only comment I would make is it's very important. This may be a nuance of the decision that's not completely apparent, but I think it's very important, one, when you're bringing a fee motion, to make it clear that the judge doesn't have to find that somebody violated Rule 11, doesn't have to find that anybody's a bad actor. It doesn't make the plaintiff a bad guy or the lawyer's a bad guy. It's just a case where you got too aggressive. Two, when you're looking at the totality of the circumstances and you're looking at aggressive litigation behavior, you don't have to show, again, that somebody acted in an unethical way or, again, violated Rule 11. The court says that the conduct doesn't have to be independently sanctionable. So if you think you're in a case where your opponent's too aggressive or the merits are too weak, you need to be kind of cataloging conduct as you go, because at the end you're going to say, Judge, these lawyers were smart. They didn't cross any line violently at any particular moment. However, across the course of this litigation, it was abusive. Here is all the conduct and here's the merits. So I think those are some of the important takeaways from the Supreme Court's decision.
The other comment that I would add, and this picks up on Judge Dyke's comment about not moving for summary judgment, I think district judges may also, not in deciding whether a case is exceptional perhaps, but in deciding what kind of a fee award is appropriate, will be looking at the conduct and litigation tactics of the other side, not necessarily to say, well, they were bad actors too, and therefore they shouldn't get fees, but to determine whether, in light of the apparent lack of merit of the case, the effort put in on the other side is really appropriate. If you really believe that a case is completely frivolous right from the outset, do you really need 10 lawyers and 5 experts on the case? So I would anticipate those kinds of arguments, and I think they may resonate with some district judges.
One other quick note, too, and a district court case just came down where the judge awarded fees, but he awarded it as to the invalidity positions, not the infringement positions, or vice versa. So it's important to remember that a judge doesn't have to give all or nothing. A judge can look at aspects of the case and find them unreasonable and award fees. And so for the private practitioners, it's important that if you're in a situation where you're thinking you might get fees on one aspect of the case and not the other, you better make sure your billing records are going to be in a condition to separate out those issues.
Dominic, you had something to say?
No.
Okay.
Do we have any data points yet on uncollectible fee awards? It seems to me that I was asking about the difference between being awarded fees and actually collecting on them. It seems like a lot of the strategies that were being discussed earlier in terms of forum shopping. So incorporating in the district the day before you file a lawsuit and assigning the patent just to the corporation that holds nothing but that patent. And so I wonder whether we have seen any instances yet in which someone was awarded fees but then really couldn't collect them because the only asset that was owned by the plaintiff was the patent itself, perhaps leading to the irony that all you might get in your fee award is perhaps in bankruptcy you might get ownership of that patent you were just litigating against.
I haven't seen any case dealing with that issue yet. I'm not even sure I've seen an article dealing with that issue, but I think it's correct. If you have the context of a bigger company suing a smaller company, that's not going to arise. But obviously, if you get into non-practicing entity litigation, that's certainly going to be a concern. Some of the legislation, and David, earlier you made the point that legislation still may come. I didn't mean to suggest that legislation might not come. I think in the fee area, it's less likely, but certainly if we start getting fee awards and there are games being played by non-practicing entities, that may be an area where legislation comes into play. Otherwise, you're left with, corporate law to try to pierce the corporate veil and to show that an entity was undercapitalized and operated with an improper purpose.
Other questions?
Well, I think the legislation was dealing with some bonding issues, which could go to the bankruptcy question. But one interesting overlap with some of the later panels, the 101 jurisprudence is such a mess that this may prove to be a very significant factor in what kind of cases are brought. That now if you're in the business as a plaintiff lawyer of bringing these kind of cases, now this would make it very hard for you to fund that kind of litigation. And then the other point you make, which is that the issues are all tied together. So if you have a bad validity case, why would the court then not award the fees on your infringement claim? They seem to be a domino effect that is implicit when you have a weak, when you have an abstract claim.
Well, I think if you can show, I think a district court's going to always have discretion to decide whether one position was really weak and that gets rid of the whole case, therefore fees are awarded across the whole case, or the district court judge still has discretion to say, I think aspects of your case were reasonable and I'm still going to, only allow half the fees. That's part of the discretionary, doctrine that we have now. And it just happened. But it's a good point. I understand your point.
This is less question, in fact, no question. It's more comment in that the discussion about will the fee shifting cases bleed into willfulness is that on Monday at the Federal Circuit there was an argument dealing with willfulness, and the panel, so kind of sua sponte, brought up, what about Highmark and Octane, right? And so they're quite aware of it. There seemed to be a pretty strong suggestion on the part of the judge that was asking the questions, that Chief Judge Prost, that these clearly do impact and will impact the way that they treat willfulness. So the case is Stryker versus Zimmer, so it's a case to watch.
The only distinction I would add on the willfulness comment is if you have a finding of willfulness, a judge has the ability to enhance damages treble, which means it is punitive in nature, which means that there should be, in my view, a higher standard to get willfulness than attorney's fees. But if you've shown willfulness, that should increase the odds of getting attorney's fees.
I'd just like to ask briefly here, if there's anybody here from McAndrews and Held in the Law that would like to comment on that Stryker and Zimmer case. I know they're sponsors, and I know someone will show up later. Maybe we'll have to catch them with cocktails this afternoon.
So I have a question about the relationship between the Supreme Court and the Federal Circuit, and I think, Dominic, you may have referred to this before. You thought the issue was pretty clear, and the Federal Circuit was applying an interpretive method that was different from looking at general statutes out there in other contexts. And I think the Supreme Court, in numerous patent cases that it's reversed, has sort of signaled to the Federal Circuit, we don't like rigid tests, and we don't like things that are sort of peculiar from the general way of approaching a text. And yet, the Federal Circuit, I think, keeps on coming up with these decisions that end up having a similar sort of problem or mistake, if you want to call it a mistake. And I guess I'm just wondering, in your experience with the Federal Circuit decisions, are we just seeing sort of the handful of cases that they make that mistake, or do we think that they are just not really getting the message that the Supreme Court is sending sort of year after year with some of these reversals?
Well, so my personal opinion is that, every time one of these cases comes up, the litigants who are defending the Federal Circuit's sort of patent-specific rule trot out a number of different reasons in which, for why patent cases are different, right? In the Highmark case, patent cases were different because of the peculiarities of patent law, the fact that district courts are unfamiliar with it in many jurisdictions, et cetera. There's always an argument like that to be made. I think that it's not impossible for arguments like that to sway the Supreme Court, but they rarely do. And so I think that the Federal Circuit is swayed by them more frequently. They come up with these patent-specific rules. And, again, litigants defend them using those arguments on appeal to the Supreme Court. Generally speaking, the Supreme Court hasn't accepted them, as I agree with your characterization that usually when the case comes down, the court doesn't want to look at it through a patent lens. It wants to compare the jurisprudence in the patent area to other areas and make sure it's not going off the rails. And so I think the Federal Circuit will keep coming up with doctrines like this in certain areas because obviously patent-specific arguments resonate to it in ways that they do not to the Supreme Court. So I would expect, will the court get the message? I think it will, and yet I don't think that we'll stop seeing these sorts of cases altogether.
Yeah, can I mention a case that I think is vulnerable, a Federal Circuit case, and it deals with what Tim Holbrook just mentioned. Maybe this is the point he was making, is the law on willfulness. So the statute just says that the court may enhance the damages up to 3 times the amount assessed. It does not say that that is tied to willfulness and that there has to be a finding of willfulness. The Federal Circuit has in banc found that that is true, that it must be willful infringement before there's an enhanced damages. But if you look at the findings of this, the holding of this case and the reasoning of, the Octane and the Highmark case, it seems like that Federal Circuit in bond case is vulnerable. Like they have a special interpretation of a statute that is not driven by the words of the statute.
Do you think, and maybe this is a little bit unfair, a lot of these rules were promulgated a while back, these patent-specific rules. Do you think the Federal Circuit's approach to this would be different if they actually had more former district court judges sitting on the bench?
I think that it absolutely would be. I think my practice is a general appellate practice, although I do a lot of Federal Circuit work. I think appellate courts in general sometimes lose sight of what actually happens in a trial. You sometimes see rulings and you wonder, have they ever actually been in a trial courtroom? You probably see this all the time.
I totally agree.
And I think the Federal Circuit had sort of had that problem in spades. Now, I think the addition of, for example, Judge O'Malley, I think will have a difference and make a difference. And I think Judge Taranto, who was a practicing attorney, I think you'll see it change. But I do think that some of the problems, if they're problems that we see, are because you have appellate judges who don't really have a good feel for trial court litigation.
I've got a question here in the back. Do any of you know of a case, post-Octane Fitness certainly, but even before, where a defendant recovered fees in a situation where they killed the patent fairly swiftly in a re-exam or now under the CBM review process? And the reason I ask that is because one of the things that even under Brooks Furniture that I saw, and I think it might still be difficult now and may make the post-Octane Fitness world not as strong as I was hoping it might be, is that when a patent was killed swiftly and the district court litigation was stayed in the interim, that the judge perceived that therefore there wasn't a lot of time for bad actions to happen. There wasn't a lot of time. There weren't a lot of fees that had necessarily accrued in the district court action, and shied away from the idea that this could possibly be a Section 285 exceptional case. So I'm curious if anybody's seen, again, either pre or post Octane, where a defendant was awarded fees in that sort of situation. And a follow-on, I'm sorry, but a follow-on to that is that I don't think it should be any less an exceptional case just because the amount of time and fees are low, relatively low, versus 2 years of litigation and having all the bad actions that occur, certainly in a willful infringement case where you've got a lot of time for bad things to look bad.
We've been tracking all the cases that are coming out since Octane, just for the amusement of it, but I haven't seen any that have that fact pattern either before or after. The only comment I would have is I think it would be important to show that the plaintiff was aware of that art before they brought the suit. Because if they're not aware of it, I think it's really hard for a district court judge to find that they've acted in some unreasonable way, which is why I would say, one of the strategies that we're employing at our firm, and I would expect many to, if I think I have a very strong non-infringement position because, for example, the plaintiff has not appreciated my technology and how it operates, or I've found a killer piece of prior art, I think you have to bring it to their attention immediately. And I think if once you've brought it to their attention, you've said, look, I think you're under Octane here, and they proceed at that point, I think the district court's got a much better record from which to say you should have stopped your case right then. If you just go right to re-exam, I think it's really hard for the district court judge, if the plaintiff didn't know about it, to award fees in that case.
Do you think there's any role, when you say that the plaintiff wasn't aware of this piece of prior art, this piece of killer prior art? What about the possibility of a judge saying, well, you should have known that. You haven't done your job. Do you think that that's a possibility and award fees on that basis?
I would expect sophisticated judges in the good jurisdictions to not go that way. Maybe somebody in Arkansas might. I don't know if they don't have enough experience. But, we all know. I mean, you get to spend $1,000 for a prior art search up front. We all know it's imperfect. We know that once a product's worth millions and millions of dollars, that a defendant who's trying to compete is going to spend a lot more to try to invalidate that patent. So I think it's unreasonable to expect plaintiffs to know of all of that prior art up front, is my view. I don't know if you guys disagree.
No, I agree with that. And, remember, there is a presumption of validity of an issued patent.
Right.
And absent the plaintiff actually knowing of a reason why that presumption should not apply, I think a district judge would be and should be reluctant to do that kind of thing.
How about in the extreme case? And I speak about this from personal experience, where you get sued and you talk to the plaintiff and say, well, haven't you seen these? Well, in the discussions prior to the suit, we would say, well, what's the prior art look like? Because he wanted to license it to us. He said, there's nothing there. We ultimately didn't license it. He sued us. In 30 minutes, we found 35 pieces of prior art. I think maybe in those extremes, the judge might.
I think that's right.
Yeah, sure.
Yes. Any other questions from the audience?
Does this have any different effects as far as a prospective DJ plaintiff who sues to invalidate, as opposed to a patentee plaintiff up front who sues for infringement?
I think it applies equally to any litigant, whether you're a defendant or a plaintiff, whether you're in a DJ posture or not. I think Octane applies to everybody equally, and I think there's just a case that came down from the Third Circuit that's now said that Octane applies in trademark cases. So I think it's going to apply to everyone.
Anything else? Well, I'd like to thank our panelists for what turned out to be a very interesting discussion.